well, you might find out. I'm like, you need a break? You need a break? Yeah, I think you need a break.
Absolutely.
You old guy, you need a break. It's not the female. Yeah. So here's what it says. This is partly just to give me something to do when I run out of my meager. But it has these things. Good morning. Hydrate yourself. Remember your goal. Keep chugging. Feeling awesome. Don't give up. Awesome.
Good morning. The Commission on Ethics meeting is called to order, and the Secretary will call the roll.
Here?
Here.
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 We have a quorum present. We are missing our chairman this morning, and we are missing due to illness Commissioner Meggs, but we have a quorum. Commissioner Gilzine, will you lead us in the pledge to the flag?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
I want to make some preliminary announcements, but before I do, I want to welcome our new Executive Director, Kerry Stillman. As you know, her history with the Commission is lengthy. Her service is outstanding. And when the vacancy occurred, the Commission did a national search. We had applicants from all over the country, as well as those from the state of Florida. And we narrowed those down to 4 finalists and had extensive interviews with those 4 finalists. And in every single category, Kerry came out on top. And it wasn't because she was already here. It's because she was the most outstanding candidate and the obvious person to select. And we unanimously selected her, and she assumed this office on the first day of this month. Later in her report, she will tell you a little bit about some changes that have been made in the staff as we move forward. So, Kerry, we're just very delighted that you're here. I do have some housekeeping announcements, the normal ones. The First District Court of Appeals graciously lets us use these facilities, and so we have to abide by their rules, the same as apply to any other functions in here. There's no food or beverage other than water in this room. Please make sure that you silence your cell phones. Anybody who's addressing the commission, please speak up. First of all, the acoustics in this room are not the greatest, and everything is recorded. So please make sure that you speak into your microphone so that you can be heard by not only the members of the commission, but other people in the room. Our agenda goes from now until it is concluded, and we will try to move it along as rapidly as we can without compromising the process. Everybody will be given an opportunity, whether commissioners or members in the audience, to make their comments, but we ask that you make them as brief as possible and to not be repetitive. Pursuant to Section 286-0114 of the Florida statutes, members of the public have the opportunity to have input in matters before the commission, other than those cases that are in a quasi-judicial capacity. This means the public can have input on matters other than complaints, opinions, and determinations of financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker card and give it to Mrs. Fulford, whose hand is up in the back holding those cards. The next item is the approval of minutes. They have been circulated and read by members of the commission. Do I hear a motion that we approve the minutes as published?
So moved.
Second.
There's a motion by Commissioner Gates, seconded by Commissioner Gilzine. All in favor, please say aye.
Aye.
All in negative, say no. Our first item is En Re Franz Pierre, number 16-130. Will the parties or their counsel please identify themselves for the record?
Mark Aaron substituting for Ben Cutie on the
Okay.
Elizabeth Miller, advocate for the commission.
Okay. We have before us a proposed stipulation between the commission advocate and the respondent. The commission may vote to approve or reject the stipulation. This is not a pre-probable cause stipulation, so if the stipulation is rejected, the matter will be heard by the Division of Administrative Hearings, or the parties can attempt to arrive at a new stipulation. Complainants have the right to comment in writing on proposed stipulations. No comment has been received in this case. Ms. Miller, you are recognized to present the stipulation.
Thank you. Good morning, commissioners. As I stated, Elizabeth Miller, advocate for the commission. Excuse
Pull
me,
your
sir?
mic down a little bit.
This better? Okay,
Yes.
thank you. Sorry, thank you. Okay, we have before you a stipulation, a joint stipulation of fact, law, and recommended order. I would ask that you adopt it. As you see in the stipulation, the respondent admits to allegations 1, 2, and 3. He denies allegation 7, and no probable cause was found on allegations 4, 5, and 6. The reason that I think this stipulation is appropriate in this case, it is a very, very serious case, as you know, but he was punished criminally. He pled guilty to 2 second-degree felonies, 9 third-degree felonies, and there were a total of 11 criminal offenses. He was adjudicated guilty. He was fined $2,000 to refund or reimburse the city of Miami Beach. and he was suspended from his position by the governor. He subsequently resigned. Due to his poor health situation and due to his indigent status, I think those are situations that certainly enter into the low fine. He is going to be, if you agree to this, censored and publicly reprimanded by the governor, and he will pay a $1,000 fine. Thank you very much.
Are there questions of the members? Mr. Herron, do you wish to respond?
Mr. Chairman, the advocate has done a good job of presenting all the facts on both sides of the equation here, and we urge the commission to adopt the stipulation.
Are there questions from members? Do I hear any discussion from members? Do I hear a motion to approve or reject the proposed stipulation?
I'll move to approve.
Commissioner Waldman moves. Is there a second?
Second.
Commissioner Carvajal. All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. The next item, as Ms. Hadley comes forward, is Melissa Holland. Ms. Hadley is the advocate. Mr. Herron, you're standing up. I assume you are.
Mark Herron on behalf of Melissa Holland, Mr. Chairman.
All right, then you're recognized. This is a proposed stipulation between the commission advocate and the respondent. It's one the commission can approve or reject. It's not a pre-probable cause stipulation, so if it is rejected, it would be heard by the Division of Administrative Hearings, or, of course, the parties could work to arrive at a new stipulation and bring before us at a later meeting. The complainants have the right to comment in writing, but no comment has been received in this case. Ms. Hadley, you are recognized to make your presentation.
In this case, respondent Wildemere Palm Coast violated Section 112.3136 by using her public position and/or public resources to benefit herself and/or her employer regarding emails sent to the City of Orlando. Through settlement discussions, the parties have come to an agreement. In the stipulation, respondent admits that she violated Section 112.3136 and agrees to the entry of a final order recommending a civil penalty of $1,000. We respectfully ask for the Commission's approval of the joint stipulation.
Okay, thank you very much. Are there questions from members? Not appearing. Mr. Herron, you're recognized.
Mark Herron on behalf of Melissa Holland. You may remember we considered this case at the last meeting. There was extensive discussion about the issues in the case, and as a result, Ms. Holland agreed to the joint stipulation, and we'd ask that the Commission adopt it. Thank you.
Are there questions from commissioners to Mr. Herron? Is there a discussion? Is there a motion by a member of the Commission regarding the stipulation?
I move approval of the joint stipulation.
Commissioner Ankers moves approval. Is there a second?
Second.
Second by Commissioner Waldman. Is there any discussion? All in favor, say aye. Aye. All opposed, like sign. Show it adopted. Thank you, Mr. Herron. Item 5 on your agenda is a consideration of advisory opinions. We have before us 2 on the agenda. And to remind you, any public officer, candidate for public office, or public employee in Florida who is in doubt about the applicability of the disclosure law or standards of conduct subject to himself or herself or anyone who has the power to hire or terminate another public employee may seek an advisory commission, opinion from the commission. Advisory commissions' opinions are issued on the facts provided by the requester and only upon those facts, and are legally binding on the conduct at issue. They apply not only to the instant request, but they become a part of our repository of advisory opinions that can be relied on by others. The first is number 2782. It's an opinion draft that, Commissioners, you will recall we previously considered at our July meeting and asked the staff to make some changes to the final draft and bring back before us. They have revised the draft, and it's identical to what the Commission asked them to do, with the exception of the highlighted language, which I'm sure you have noted. Steve is before us, and he'll present the revised draft for your consideration. Is the requestor here?
The requester is here today. Representing the Office of General Counsel for the University of West Florida is Assistant General Counsel Michael Wyatt, and he's accompanied by Assistant Vice President for Sponsored Research, Dr. Schwartz.
Okay. Welcome to our commission. Okay, Steve, you're recognized.
Thank you, Mr. Chair. Commissioners, you are, the chair is correct. You did see this opinion last time. We talked extensively about it, and there were some changes that were discussed, one that I was proposing, and then as the discussion developed, it became clear that certain other things were important to certain commissioners. I included some elements of the discussion in the new draft before you. I highlighted all of the changes. If you need me to take you through the entire opinion, I can, but I'll take you through just the changes very quickly. On page 3, there's a change there. Commissioner Lesnoff had indicated last time that it made a positive difference for her, the fact that the RAE has experience receiving prime awards and has experience making sub-awards, and because they have that experience making the sub-awards, that was relevant to their making a grant for the IRDF. That's included on page 3. Footnote 2 on page 3 is derived from statements that Dr. Schwartz made from the podium last time. That he indicated that the trustees are not involved in the awarding of grants from the IRDF. I thought that that was important to include, so we added it. On page 4, footnote 3, during Commissioner Carvajal's questioning, I indicated that it was not the business of the chair of the Board of Trustees that was applying for the grant. That seemed to be important to the rest of you. During the discussion, I included that fact in the draft. On page 7, that was the edit that I had discussed with you last time, just clarifying what the legal opinion of the Office of General Counsel for the University of West Florida was. We had discussed that last time. It's now included. And then on page 7, footnote 5, this is the language that you were looking for to stress that this opinion is for these narrow circumstances, and that if the chair of a Board of Trustees seeks the exemption in 112.313 subsection 12H, they will need to come to us for an opinion on that matter, that this opinion does not reach those circumstances. The new draft is offered for your consideration. I'm available to answer any questions that you may have, and if you have any additional questions of fact, the requesters are also here.
Are there questions from members of the commission?
Just a-
Mr. Wallman.
Thank you, Mr. Chair. I think you said, just for the record to be correct, you said footnote 5, but it's footnote 7, I believe.
It is, I'm sorry, I numbered these on my notes. It's footnote 7. Thank you.
Are there further questions? Okay, the requestor is given an opportunity to speak. Do either of you gentlemen wish to make a presentation?
Good morning, Mr. Chair. Michael Wyatt on behalf of the University of West Florida Assistant General Counsel. I'd just like to thank the staff for their effort that they've put in. They've been great to work with, and we ask that the Commission approve the opinion as drafted.
Are there questions of the requestor from members of the Commission? Commissioner Ankers.
I don't have a question, but thank you for your patience in waiting for us to look at these revisions and updates to make it a little tighter and more applicable just to the University of West Florida.
Of course, thank you.
Are there further questions or comments? Commissioner Gates.
Thank you, Mr. Chairman. I'd like to compliment the University of West Florida for coming to the Commission and asking for an opinion, as opposed to doing what, some might do, and that is to plow forward and hope that the devil will take the hindmost. I believe this is the right thing for an institution of higher learning to do under these circumstances, and given the narrow circumstances that are described here, I'm very comfortable with the opinion, and if it's appropriate, I would move to accept the opinion as presented to the Commission.
Is there a second to the motion?
Second.
Commissioner Ankers seconds the motion made by Commissioner Gates. Is there discussion? All in favor, say aye.
Aye.
All opposed? Show it unanimously adopted. Thank you, sir. I will echo what Commissioner Gates said, and I wish more people would proceed in the manner that you have proceeded.
Thank you, Mr. Chair, and thank you to the Commission.
Our next item for consideration is file number 2784. Is the requester here? All right. Thank you, sir. I'll call on you in a moment. This is a written request for withdrawal of an opinion that's been filed by requestor's counsel and is distributed to you for consideration. Pursuant to Commissioner rules, withdrawal of an opinion at this stage of the proceeding is permitted only for good cause shown. I raised a question when I was discussing this with Ms. Stillman that if someone asks for something and they decide they don't want it, why shouldn't they be able to withdraw it? And the answer is that the Commission rules don't provide that they can, absent permission of the Commission, and for a very good reason. Let's suppose that I make a request of the Commission and the staff drafts a proposed advisory opinion, and it's not what I wanted it to be, and so I just soon not have that as a matter of record, and I just say fold the tent and forget it. And that's not an option that a requester has. And so that's why this matter is before you. Yes, the requester filed it. Yes, the requester has asked to terminate it. But we have to approve that. And so I just want to make that known. It was something I didn't totally understand, but I do now understand, and we're going to proceed accordingly. You're recognized, and here is the withdrawal request that is being circulated.
Thank you, Chair. I'll give you all just a chance to review it for those of you who haven't received it yet. It's all right, I'll proceed if you all have had a chance to review.
Everybody had an
this
opportunity to
more
read
time.
it. You may proceed.
Commissioners, this opinion deals with the application of Section 112.313, subsection 9A4, which places a 2-year lobbying prohibition on certain former executive and legislative branch employees returning to lobby before the agency where they were employed. As Commissioner Grant stated, after the draft was circulated to you all, we received this letter from the requester earlier this week asking that the advisory opinion be withdrawn. And as Commissioner Grant explained, our rules state that once copies of a draft advisory opinion are circulated to the Commission members in preparation for an upcoming meeting, that opinion can only be withdrawn upon consent of the Commission for good cause shown. So the preliminary question we have here is whether good cause has been identified in the withdrawal request. Now, in the letter before you, the requester indicates he has no current plans to leave his position. He also indicates it's in his best interest for the opinion to be withdrawn to promote the overall continuity and effectiveness of his position, and because he's currently hiring new staff. Commissioners, I do not recommend you find these reasons to be good cause to grant the withdrawal request. Clearly, the requester felt there was a pressing enough need to clarify the application of this 2-year lobbying ban as recently as July 21st, when he hired an attorney to send the letter into the Commission. Moreover, it's difficult to see how clarifying the application of this post-employment statute to him will affect any hiring decisions that he currently has to make. So, given that, my recommendation is that you deny the request to withdraw, but I'm happy to answer any of your questions on it. And I do know that Mr. Rivers, the requester's attorney, is here today and would like to speak to you all about the withdrawal request as well.
Are there questions from the members of the Commission? Mr. Rivers, you're recognized.
Thank you, Mr. Chairman. I'll be brief with regard to the preliminary question. Understanding full well the purpose of the rule that someone should not be allowed to ask for something, not like the answer, and then say never mind, I certainly understand that. The initial request for the advisory opinion was not prompted by any specific plan or course of action that was intended post-public employment. It was thinking about the future. This person has been in their position for a number of years and, again, with no specific plan, but wanted to know what if I, was to leave my post and go into the private sector, what would be some limitations that might be placed upon my post-employment restrictions. So to where we are now is the request is effectively mooted in the sense that he has no specific plan, and the concern is, my client's concern is, this puts him in the position of, okay, it's moot insofar as I'm staying in my position, and by staying in my position, am I now putting the effectiveness of this post that I occupy, am I putting that at risk with a perception of, I've got one foot out the door, I'm not invested in this. As you may see in my request for the advisory opinion, the position has undergone, we obviously have some different views as to what the legal import of those changes are, but it's undergone significant changes over the last few years. And my client would probably, use more colorful language about the efficacy of his position and where he's left. And he thinks that this will probably create a worsened situation for both him and the taxpayers that he represents in terms of advocating to the department. So that's the purpose of the withdrawal. It's for not only his own personal interests, but the interests of the job that he does and the efficacy of his office.
Thank you, sir. Are there questions of Mr. Rivers from members of the Commission? None appearing. Is there discussion? Mr. Wallman.
Thank you, Mr. Chair. I'm kind of confused because you said he didn't have any plans initially, but he asked for the opinion, and then now he doesn't have any plans and he doesn't want the opinion. So it doesn't seem like anything changed. Did I misunderstand?
No, to the best of my knowledge, there was not a specific plan for post-public employment, and still now today, there's not a specific plan. Now, certainly, depending upon what the response of the commission had been, he may have charted a particular course, but no, I'm not aware of anything as we sit here today.
It seems to me that this is a little different than most of our advisory committee opinions are for here and now.
Right.
You know, can I do this? And this is, what if something happens in the future that's not applicable at the present time? And, you know, that frankly concerns me a little bit. Usually advisory commission opinions are requested to the commission for people and how to conduct their current public position, whatever that position may be. But this is, you know, if I change courses and I'm no longer a public official, can I do X? And that makes it somewhat different. That doesn't mean that we ought to withdraw it, but I find it to be strikingly different from most every other advisory opinion that's been asked of this commission. Is there, Commissioner Carvajal?
Not for question, for discussion, right? So the first thing, to your client's perspective, I will say it is good to hear that he plans to stay, because the taxpayers advocate's position is a very important one for the state. It's one of the few voices that they have representing the Department of Revenue. But I would add that advisory opinions don't have to be instant cases. They have to be examples, if I'm not mistaken, and can extend beyond any one example. It would not matter who the advocate is or when the advocate is. This interpretation would apply to them into the future, so it doesn't matter if it's this particular client. With all due respect to the fact that he has no intentions of leaving, I think that we should go forward, and I would argue that for three reasons. The first is the greater protection is to the taxpayer, in this case the citizen, not necessarily the incumbent in the seat. If they do not know what the clarity is, that could potentially harm them either during the processes where he or she is representing them, or after, where maybe the client in this case would pick up a case afterwards and compromise then the taxpayer's position. So I think this is an important question to clarify, and I should also clarify, with my seat at Florida Tax Watch, I have a great interest in Department of Revenue and tax issues. The second thing is that this would at least send a very good signal to the legislature that this is a question that might need to be clarified if there is clarification needed. I like the opinion, I intend to support it, but I don't want it withdrawn because it protects the taxpayers to a great degree, and I think it sends the signal that more clarity needs to be put in if needed.
Thank you. Further comment?
So, Mr. Chair, just for clarity's sake, what we have before us that's not a motion yet is to withdraw the opinion. If we choose to keep the opinion, then what happens next?
Well, as I understand it, the opinion is before us for approval or rejection.
Got it.
The requestor has made a motion or a request that it be withdrawn.
Okay.
And so I think we have two considerations. The first consideration is, do we allow it to be withdrawn? And if we do, it goes away.
Right.
If we do not, if we follow Commissioner Carvajal's line of reasoning, then we simply act on the advisory opinion in the same manner that we would act on any other advisory opinion.
Got it. Okay, so then we'll have a discussion, we'll have a full-blown presentation on the opinion.
That is correct.
Gotcha.
We'll either do it now or we'll bump it to the next commission. We'll have to decide that. Commissioner Gates, you look like you want to say something.
I was looking at my more learned colleague at the other end of the dais, Mr. Chairman.
You must be talking about Commissioner Walden.
All of my colleagues at the other end are learned, but I was looking at Commissioner Walden, he's hand up.
I do have a question, though,
Yes.
procedurally, because we could actually even accomplish the same thing, of course, by not approving the opinion, would do the same thing. So if we didn't at this stage say it's removed, if it's voted down, then it does not become part of the record. Would that be correct?
Yeah, that's, I mean, the same as any other advisory opinion.
That is correct. Rule Chapter 34-6 governs advisory opinions of this agency and provides that the trajectory which the chairman so well articulated in the instance of a request for withdrawal. Rule 34-6.006, subparen 7, provides that you will initially take a vote up or down on the request itself to approve or deny the request for withdrawal. And that's predicated upon the standard that Gray mentioned in subsection 7, which is that of good cause shown, which is not defined, so you have a lot of leeway to make that determination. Subsequent to that, you will have a full presentation on the opinion itself, which under the same rules contained in Chapter 34-6, you can reject, accept, or modify. As we saw in the last advisory opinion that was presented to you, it was subject to modification to make it satisfactory for subsequent approval. That is still within your purview, and so that's the posture we find ourselves in. A twofer, if you will.
Thank you.
Mr. Chairman,
Yes.
I move that we reject the good cause requests.
All right. There's a motion before us. Is there a second?
Second.
Mr. Carvajal seconds. Is there discussion? Now, I remind you, this is not discussion on the advisory opinion. This is simply a motion as to whether or not we accept or reject the withdrawal.
Yep.
Is there discussion?
I just feel a little bit, I'll start over and say that there's a voice in my head from almost 30 years ago when Larry Fuchs was the executive director of the Department of Revenue, where I had a short stint in a policy position, and he made every employee in the agency read The Death of Common Sense, which was a little book, a pamphlet of sorts back then, but it was a real hardback book. And so when I saw this request, I thought, well, that's Larry Fuchs. It's common sense that if somebody doesn't need it, that you just revoke it. And that was my position, but subject to me, the comments that you've made with respect to why this may have some benefit policy-wise, then I'm all right going ahead with the denial. But I felt that I owed him some homage, and since this is from that agency, that I at least heard that once, and but I think that common sense can be interpreted in more than one way.
Is there further discussion? All in favor of Commissioner Gilzean's motion, say aye.
Aye.
All opposed? Mr. Rivers, the request has been denied.
Understood, Mr. Chair.
Now, we will proceed in the normal fashion with the presentation of the advisory opinion. At the conclusion of that presentation, there are really three options. One is to accept it, another is to reject it, and another is to bump it for further consideration at the next meeting. You're recognized.
Thank you, Chair. This opinion request, as said before, concerns Section 112.313, subsection 9A4, which is one of our post-employment statutes. The statute applies to certain former executive and legislative branch employees who are serving in senior management service or senior exempt service positions. It places a 2-year prohibition on them returning to lobby clients for compensation before the agency where they were employed. The key phrase to zero in on here for the purpose of this draft opinion is the part of the law emphasizing that this 2-year ban just pertains to the agency where the public officer was employed. That's the wording chosen by the legislature. The requester here serves as the taxpayer's rights advocate, as you've heard. It's an SMS position, meaning he is subject to the 2-year ban in Section 112.313, subsection 9A4. He doesn't dispute that. The issue here is the identity of the agency where he's employed. Given some recent statutory changes to his responsibilities, which Mr. Rivers mentioned, his argument is that the agency where he's employed is the Office of the Chief Inspector General within the Governor's Office. He claims a 2-year lobbying prohibition should apply then to lobbying the Governor's Office alone. But for the reasons laid out in the opinion, I'm recommending that his agency was and continues to be, even after the statutory changes, the Department of Revenue. Let me explain why. Just to give you an overview of the position, and this is all taken from the statute, the advocate's position was created by law to review actions taken or proposed by DOR. The advocate responds to taxpayer complaints about unsatisfactory treatment by DOR personnel, and he looks into issues that can't be resolved through the normal administrative channels at DOR. He also issues an annual report identifying problems in DOR's procedures and recommending possible solutions. DOR is not required to accept his recommendations, but he does have the power to temporarily suspend or stay DOR actions if he finds that they result in, the statute says, significant hardship to the taxpayer. So his responsibilities solely concern DOR. Now, prior to 2018, his position was housed within DOR, and the position reported to the department's executive director, who also had the power to appoint someone to that particular position. But during the 2018 legislative session, some changes were made to his responsibilities in the statute. Now, the draft goes over those changes in detail, but essentially, the law began to require the advocate to report to the Chief Inspector General in the Governor's office, and it gave the Chief Inspector General the power to appoint and remove someone from the position. And from what we've been told, this was done to increase the objectivity and independence of the taxpayer rights advocate, to free him up to take positions that might even be contrary to those espoused by DOR. Now, given the new reporting requirement, he's arguing here that his position was effectively transferred to the Chief Inspector General's office, meaning that there would be nothing restricting him from lobbying DOR within 2 years of him leaving state employment. But for the reasons given in the draft before you, it doesn't appear to me, at least, that the legislative changes were intended to transfer his position outside DOR. The statute creating the position stated and continues to state, after the 2018 changes, that the advocate's position is housed within the Department of Revenue. In fact, the final staff analysis of the legislative changes, which is included in your meeting materials, states the position is still within DOR. So the legislature did not touch that language in the statute, although it had the ability to do so if it wished. Also, the legislature made an addition to the statute in 2018. It stated the advocate will be subject to the general supervision of DOR's executive director for administrative purposes. And that seems strange if the legislature's intention was to transfer the position to the governor's office. Now, I've done some research into some publicly available materials, which are included in the draft in front of you. My research shows the state's payroll system still considers the taxpayer rights advocate to be a salaried DOR employee. And the address on the advocate's most recent W-2 matches a P.O. box used by DOR. And it appears to me that DOR still claims him as one of their employees, because their website still contains a page for the Office of the Taxpayer Rights Advocate, and on the annual list of disclosure filers that they send over to the Commission on Ethics each year, they continue to include the Taxpayer Rights Advocate. He's not on the governor's list of employees, he's on DOR's list. Now, applying all this to the statute, our ethics laws are penal in nature. And that means that by law we have to read them narrowly. We have to confine them to the exact words used and chosen by the legislature. We can't read them broadly to go beyond that. Now, the law here states that the 2-year ban is just applicable to the agency where the public employee was employed. And the Commission has found in the past, in opinions that I've laid out for you in the draft, that means your agency is just where you're employed, even if you owe responsibilities elsewhere. I will say that other post-employment statutes concern holding responsibilities regarding various contracts. Those, I suppose, could bleed over into other entities besides your own. But the legislature, when it wrote this particular statute, just talks about the agency where you're employed. So my recommendation here is that clearly the advocate's position has been uniquely treated by the legislature, but while he may have some reporting obligations to officials outside DOR, he appears to still be considered a DOR employee by statute, as well as by the other information I've laid out. I would argue that he's still employed by DOR, even considering the legislative changes. So in closing, my recommendation is that you find the advocate's agency, for the purpose of the 2-year ban, is still the Department of Revenue, and that means that he'll be prohibited after he leaves state employment from lobbying DOR for 2 years, unless, as Commissioner Carvajal indicated, the legislature disagrees and wants to change the law, which certainly be its authority to do so. I offer this draft now for your consideration. Happy to answer your questions.
Are there questions? Commissioner Gilzine.
Yes. So Article 2, Section 8, 3 of our Constitution states that it's a 6-year ban. Why is that not applicable here?
Well, the 6-year ban, Commissioner, does not go into effect until, I believe, the end of next year.
Gotcha.
And even then, it is just going to be applicable, according to the language in that particular amendment, to certain public officers. I think it lists statewide elected officers, members of the legislature, county commissioners, school board members, school superintendents. It doesn't list the taxpayer rights advocate. So I'm not certain that that 6-year ban will apply to the advocate's position, even when it does go into effect.
Commissioner Carvajal.
Thank you for the presentation. I still have a question on how to resolve this in the best interest of the taxpayer at the end of the day. And I'm trying to identify the moral hazard here. So obviously an advocate that defends or opposes against the Department of Revenue who's thinking potentially that they might have an inside track later is in itself a moral hazard. But if we leave the door open for them to lobby the governor and thereby the Inspector General's office, isn't there also a moral hazard and a risk there?
Commissioner, I think what you're getting to, and I think I mentioned this in the opinion, clearly the purpose of the statute was to prevent influence peddling. Returning immediately to lobby agencies where you might have the inside track or inside connections. That clearly was its purpose. But again, as an agency, we are confined by the language that is used in the statute. The language does not talk about subject matter where you're involved, personnel where you've interacted, or entities to which you owed responsibilities, as other parts of the Code of Ethics does talk about. The language used by the legislature is the agency where you were employed. And I struggle with that as well, but given what we've done in the past and different advisory opinions, it seems pretty clear to me that we just don't have the authority to read beyond the wording that the legislature has chosen. And I would remind the commissioners that our ethics laws are penal in nature because they can result in disciplinary penalties, and that means the appellate courts have clearly said we have to read them narrowly as an agency to not go beyond the scope of what the legislature has given us.
For follow-up, Chair. So I actually agree with everything you just said, and that's why I would support as written. But my question isn't about an opinion, potentially for a footnote or anything else about the other moral hazard that is raised. I mean, I know that the ruling would have to go in accordance with the law because we cannot supersede regardless of the interpretation. But our role is protecting the public's trust. And I think it's worth a mention that the public's trust still has an open door that is compromised if they are able to lobby the Inspector General's office and the governor's. I don't disagree with the direction of the opinion, but I do think it's worth exposing that law if one of the arguments that I would make later on is the legislature should look at clarifying these things.
Further questions or comments? Commissioner Gates.
Thank you, Mr. Chairman. I would agree with Commissioner Carvajal that there ought to be a footnote or some reference made to what he properly describes as the other moral hazard. And, if that could be a respectful nudge or a nod toward the legislature about, in effect, closing both doors as it pertains to this case, that would seem to me to be the proper role of this commission. Commissioner Gilzine raises very properly the issue of the 6-year ban. And later in our meetings, we'll talk about
the extent to which we're going to respond to the request for guidance that's come to us from members of the legislature as to how they implement that. As they do, you're absolutely correct, Counsel, that the constitutional language is specific as to positions. Now, whether the legislature at that time would choose to say, well, while we're at it, let's make everything consistent and go from a 2-year to a 6-year ban for the taxpayer advocate is a question for the legislature. But here's the context that I respectfully recommend to my fellow commissioners, and that is we are now approaching the time when the legislature will make decisions about how and how seriously to enforce the other language in the constitutional amendment that we were obliged to opine on and which we will, assumedly have some role in enforcing. And I would hope that that no message or subliminal tone would come from this commission to suggest that we're anything but serious about the lobby ban and making sure that wherever we see the moral hazard, that we shut the door to it.
If I may respond through the chair. I just want to note 2 things after hearing from Commissioner Carvajal and Commissioner Gates. First of all, I just want to remind the Commission that I do believe that Council would like to address you all on the opinion after you finish your questions for me. The other thing I would like to say in regards specifically to the comments that you 2 have raised, I could, if the opinion is approved contingent on that footnote, I could craft a footnote indicating and reminding that the general purpose of the statute is to prevent influence peddling, and that while the statute as it is written may not expressly prohibit the taxpayer rights advocate from leaving his position and lobbying the governor's office, he may want to consider the public perception of that, something along those lines, to hopefully satisfy your concerns. I don't think we would be overstepping as long as we clarify that while as the law is written, that would not be a violation. He might want to consider the public perception of that as well.
Further questions? Mr. Rivers, would you like to make any presentation?
I think this is readily apparent to you, Commissioners, but this situation is unique. This position is unique within state government, and the specific circumstances that my client finds himself in are unique insofar as there will not be anyone else who occupies this post that goes through the changes that he has experienced, unless the legislature changes the law again. But my point being, I find a client who's in a unique situation, and I'm going to try to, as best as I can, to articulate those circumstances so you understand. Again, no one else that occupies this post from this day forward will experience these changes in the law and the very real changes that have come from an operational standpoint of occupying that post and the day-to-day job that my client does. The purposes of those changes in the law was to make the taxpayer rights advocate position more independent from DOR. I mean, I'll put it plainly. If you advocate really, really, really well and you aggravate some people in DOR, they shouldn't have the authority to take you out of your post, and that's exactly what the legislature did. But necessarily, by the very nature of this job, my client still does have to work with DOR. I mean, I'm not here arguing any of the facts. I mean, clearly the taxpayer rights advocate advocates to DOR. That's the very nature of the position. But I believe the legislature has said, yes, you have to work with DOR. You have to advocate against DOR. But you are now employed by the Chief Inspector General's office. The Chief Inspector General can hire you, can fire you, can really control your employment, albeit you go to work at the Department of Revenue and you deal with revenue and taxes all day long. So the subject matter obviously is certainly still revenue, but it would be my contention that my client is employed by the Chief Inspector General. Stating the obvious, this is a position that involves advocating on behalf of taxpayers to the department. the position, or the opinion as written, would essentially say the taxpayer rights advocate, who right now, as we sit here today, advocates against the department on behalf of taxpayers, would put that person in the position of not being able to do that very thing if they leave their job. They could not advocate on behalf of taxpayers against the Department of Revenue. There's some absurdity to that. And the last thing I would say is, I think that when we're having a discussion about what the law says, I, of course, would bring it back to what does the law say in regards to the changes the legislature made in 2018. Well, the law very clearly says that my client or that position is now subject to the appointment and removal by the Chief Inspector General. To ignore that, I think, does ignore where my client is, by whom my client is now employed. And so we do have some questions as to what does the law say, but I would submit to you it's not just what does the ethics code say, it's what do these changes the legislature made to my client's position, what do they say? And I would submit to you what they say is my client is now employed by the Chief Inspector General, and he should be allowed to advocate on behalf of taxpayers against the department when he leaves his post, just as he's doing now. Thanks.
Mr. Carvajal.
Just to clarify, you're mentioning the uniqueness of this current situation. So 10 years down the road, if nothing changed and there's a different advocate that leaves, the next one would not also be under the same scenario, employed at the Department of Revenue, but reporting for hire and fire to the Inspector General?
I didn't mean that. What I meant was the uniqueness of my client being the only person who is going to have gone through the transition of the pre-2018 employment structure to the post-2018. Whoever occupies the post subsequently, they will inherit it under whatever that structure is at that point in time. But the changes that my client has undergone are quite real, and they aren't just changes in the law. They've been a day-to-day change in the operations of his office.
Further questions? Is there discussion?
Sure. On a discussion point, let me argue against my position for a moment and just mention that there
You had me on your side, too. Now you're going to lose me.
Just to be fair to the current advocate and every other advocate for the state, those are tough positions. You are working within the environment that you are constantly fighting against. And anything that makes it more difficult, not only for them to stay in those positions, but for us to recruit future advocates is a concern. I mean, these are one of the only positions that truly represent, this is not the only agency that has advocate. So I would just say there may be reason to reject this with this strong signal that clarifying these things are important. But I still feel that approving this is important because it is not the advocate in the end that needs the defense, it is the taxpayer. They need clarity about who is representing them. They don't need any confusion about whether, if after the advocate left and they represented them, the 2-year ban applied or did not apply in their particular situation. They would be more compromised if this answer was left unquestioned. So I would actually strongly support where we currently are because it creates clarity. And if it's the wrong clarity, then there's opportunity for the legislature, particularly since the advocate intends to stay, to clarify that before they leave.
Is there further discussion?
Mr. Chair.
Commissioner Akers.
The one maybe analogous position that I thought of while you were speaking is the Office of Public Counsel with the Florida Public Service Commission. And so my question is, if this was taken just as a precedent, although I realize it has limited application, would the person in that position be prevented from leaving his or her post and going to represent an environmental nonprofit or an energy conservation group, which similarly I think is what this person might do if he went to go or she went to go represent taxpayer interests. So I just want to point out that I do think there are some other applications in which this could be construed or applied more than intended.
Further discussion? Commissioner Gates.
I take Commissioner Anker's point and to respect the point, but whether or not someone is lobbying for good causes or lobbying for causes that some may consider not so good, the fact is that the issue, as Commissioner Carvajal has put it, is influence peddling. If you use the position that you have held, the public position that you have held, to now profitably peddle your relationships and your influence back before the people who make the decisions, that's something that the voters of Florida have said by the greatest majority, I think, ever given to a constitutional amendment, they don't want. And so consequently, I think well, it may be the case that that causes that I or others may find to be very persuasive causes would no longer be able to hire as advocates people who had just been in the public position and held the public trust over those matters. That is the direction that the people of Florida want us to go. And so consequently, I would support the opinion, the advisory opinion, as it's been presented. And, if in order, I would move to accept the advisory opinion and approve it.
All right, there's a motion before us. Commissioner Carvajal. Well, first of all, is there a second?
Second.
There's a second. Commissioner Carvajal.
With the urging, if possible, as the staff attorney has indicated with the footnote about the other moral hazard, if you don't mind.
Oh, yeah.
That's included in the motion, yes. I apologize.
So the motion is amended?
Yes, sir.
All right. Is there discussion on the motion? Commissioner Walden.
Thank you, Mr. Chair, and I support the position and the motion, but I just wanted to make a comment that if I understand correctly, the lobbying issue, or essentially, it doesn't preclude somebody from actually consulting and advising. It just prevents them from appearing before that agency. So conceivably, this individual, the taxpayer's advocate, could open up a business advising people, and then they can go have whoever they want be the one who appears in front of them. But you're not precluded, and if I'm wrong, please let me know, but that's always been my understanding, is you cannot appear in front of that agency.
Mr. Chairman, and if my much more learned colleagues can correct me here, but I believe that the notion here is lobby for compensation. That's the language that is prohibited. And lobby for compensation certainly includes appearing in a formal setting, but it also could and does, based on past cases, include taking money from someone and perhaps not appearing in front of the tribunal, but appearing in front of someone's desk and saying, I'm here to represent Don Gates, and I'm his advocate. Now, there's nothing in the world, as far as I know, in current law or in the constitutional language, that prohibits somebody from doing, as you say, opening up a consulting firm and saying, I'm here to share my wisdom. But the minute that they take compensation and they show up someplace in front of somebody to try to peddle their influence, that to me then presents a serious legal and constitutional problem.
Mr. Chair, just in response, Mr. Chair?
Yes.
Thank you. What I'm saying, that's an appearance. If you appear in front of somebody's desk, you've appeared in front of the agency. I'm saying if you have an office and you have other people who work for you, you can certainly advise that person, and then they can have somebody else represent them or go and appear in front of the agency. That's my understanding.
I take your point, yes, sir.
May I put a fine point on this? The restriction with which we are discussing applicable to agency employees contained in section 112.313(9)(a)(4) prohibits any agency employee during the 2 years after they leave public employment from personally representing another person or entity before their former agency, and the term representing is actually defined within Section 112.312, subsection 22, and you are absolutely correct. It is expansively defined to include actual physical attendance on behalf of a client in any agency proceeding, the writing of letters or the filing of documents on behalf of a client, and all personal communications made with officers or employees of the former agency on behalf of the client. In advisory opinions issued by this agency, we've said that that includes being on conference calls and things of that ilk. And so you are absolutely correct that it is expansive in its prohibition, but it is not all-encompassing. And it is personal to the individual former public agency employee.
Thank you. Other questions or comments? We have a motion and a second before us to adopt the advisory opinion as drafted with the addition of the footnote that was indicated in Commissioner Gates' motion. All in favor, say aye.
Aye.
All opposed, nay. Show the advisory opinion adopted. Thank you, Mr. Rivers,
Thanks for
for
your time.
being here and for your presentation. That takes us to the next item, which is item 6 on uncollectible disclosure fines. There are cases where we have imposed an order imposing a fine and then determined that it's uncollectible. And we have 3 cases before us where the individuals who have been ordered to pay the fines have all passed away. None of them are present here to rebut this suggestion. And none of them are in a position to pay. And so we can deliberate this. You have reviewed the agenda as to the various ones. Do I hear a motion that we declare these to be uncollectible and record that accordingly?
So moved.
Commissioner Akers moves. Second. Commissioner Carvajal seconds. All in favor, say aye.
Aye.
All opposed, show it adopted. Item 7 is the financial disclosure appeals of situations where fines have been assessed, and to my knowledge, none of these people have passed away. So my question is, are there any members who have filed appeals present individually or represented by counsel? None appearing. Are there questions from members? Commissioner Harville.
Thank you. Related to cases 19062 and 20026, there was a note in the file that I'd like to explore about that they were submitted to the agency and they were returned to her, so there was at least an effort to file those. So whenever appropriate, I'd like to take those up. Just a question.
Steve handled those appeals.
What?
Steve handled those appeals, so he wanted.
Okay, Steve, you're recognized.
Thank you, Commissioners. Financial disclosure appeals 20-026, 19-062. These are presented not for hearing by Cynthia Howard. Cynthia Howard is the board member of the She's a member of the Board of Governors of the Florida Workers' Compensation Joint Underwriting Association. This is a position that is required to file Form 1. We have 2 different appeals from her for 2 different form years. She failed to file timely her 2018 CE form, 2018 CE Form 1 and the 2019 CE Form 1. Both accrued the maximum fine of $1,500, and then both were subsequently appealed later. Those are the drafts that are before you. The 2 reasons, the reasons submitted in both are slightly different. In both appeals, she references that there was some caretaking going on for a period of just short of 2 years. She was caretaking for her elderly parents. In the appeal of the 2018 CE Form 1 fine, she also mentions that there was that she did mail the form to her agency, and that she noted in her appeal that the agency returned the form to her. There's no record of it being submitted to the Supervisor of Elections, or I'm sorry, to the Commission on Ethics, which is where the proper place to file that would have been. In the second appeal, there's no reference to that, to mailing it to the agency. Instead, she says that the reason for her appeal is she was caretaking for her elderly parents, and also COVID-19 was generally occurring, and there were difficulties associated with that. In both instances, the draft recommends that these are not unusual circumstances that prevented the proper filing of her financial disclosure forms.
Are there questions? Commissioner Carvajal.
Just to clarify, though, were both of these following the same path where they submitted together to the agency in return? We don't have that information in 2026. I didn't know. Did I only read it in the 19 case?
I'm sorry, say it again.
So I do recall reading it in the 19.062 case that the form was submitted to the agency in return for her. So there was at least an effort to submit it. I completely understand it went to the wrong place. And I am asking because I am inclined towards leniency, having taken care of individuals in COVID.
Sure. For the 2018 CE form, COVID was not yet a thing. But the original question, as I understood, was were the appeals submitted at the same time? They were both submitted and received by the office on April 13, 2021 for both forms. The statement that was in the appeal about the submitting it to the agency, all that we had was that she did send it to the agency. The agency notified her that that the agency sent it back to her, and then we don't have any other statements about what happened after.
Further questions? Are there, do you want to vote on these in bank or individually?
I would at least, thank you very much, Chairman, for asking. I would at least like to withdraw 19062, but if we could vote on them individually, that would be helpful.
Okay, all right. Then do I hear a motion on 19062?
I'll move it for discussion.
All right, it has been moved by Commissioner Carvajal. Is there a second?
Second.
Commissioner Wallman. All in favor, say aye. I'm sorry, discussion.
As I was indicating in the questioning, I tend to be a little more sympathetic to the caregiver role. I understand it is not always an excuse in itself, but it does seem that there were actions taken to try and file the form, albeit late. So I would acknowledge and respect the board in either direction, but I'm going to vote against it for that reason.
Commissioner Gates.
Mr. Chairman, just a question of clarification. What is the effect of the motion that's on the floor?
Commissioner Carvajal.
My understanding would be that, in particular, the fine of $1,500 would then be potentially waived That's my intent ultimately.
So that's your motion.
Whatever the proper posture is, I'm not sure. These are unusual because we usually do them in bond for different reasons.
So you're moving to waive as opposed to adopt the staff draft.
Correct.
That's what I meant to say, that I am moving to waive 19062.
All right, is there further discussion? Commissioner Wallman.
Thank you, Mr. Chair. I actually, I tend to support Commissioner Carvajal because I do believe we've taken positions recently regarding COVID and the difficulties people have had, whether it be filing or doing certain things. We've certainly done things for continuances because of it. I do think that's an unusual circumstance. I think the caregiving is important, and so I'm going to support the motion.
Is there further discussion? Motion is before us. All in favor, say aye.
Aye.
All opposed?
Nay.
Nay. I think it failed.
I will acknowledge it failed.
Okay.
I will acknowledge you're the nice guy.
Mr. Chairman,
Commissioner Gates.
so that we can have then a motion before us, I move to accept the advocate's recommendation as to the matter before us.
Second.
We have a motion and a second on file 19062 that it be accepted as presented. Discussion? All in favor, say aye.
Aye.
All opposed, like sign. Show it adopted. That takes us to 20-015. Do I hear discussion on that?
Chair,
I
I'd like
hear-
to move approval. Move approval of that.
Commissioner Waldman moves approval.
Second.
Commissioner Carvajal, second. Discussion? All in favor, say aye.
Aye.
Opposed, like sign. Show it adopted. File number 20026 is before us. Is there discussion or a motion?
Move adoption.
Second.
Commissioner Wallman moves adoption. Commissioner Carvajal seconds. Is there discussion? All in favor, say aye.
Aye.
All opposed, like sign. That takes us to item number 8. We have 2 cases, Matthew Caldwell and Mark Icy. These are both requests for extension of time in which to file financial disclosure. The law gives the chair the authority to grant extensions of 45 days, but only the commission can grant a longer extension. Draft orders and other materials are in your minutes. You have reviewed those, but Gray, you're welcome to make any additions.
Commissioners, very briefly on Matthew Caldwell. He's a Lee County property appraiser. He initially asked for an extension of time on his Form 6 because he was waiting for his 2020 tax return to be finalized. He needed some information on it to be able to accurately complete his financial disclosure filing. The chair, based on that reasoning, gave him a 45-day extension that ran until August 16th. Prior to that time, he asked for a second extension. He indicated that his tax return was coming imminently, but it just wasn't there yet. And so based on that, I prepared a second extension, extending his filing window from August 17th, when the previous one ended, until September 30th. That's the order in front of you. Since that time, though, Mr. Caldwell actually has filed his form. His tax return came in. He filed it on August 30th, meaning he filed his Form 6 on August 30th. So I guess you all have an option. You can approve, I would recommend that you approve a second extension. It's up to you whether or not you want to vote to approve the extension order in front of you, which would run from August 17th to September 30th, or that you want to have me truncate that extension order and just have it run from August 17th to August 30th, which is really the date he filed. That would be all the extension he would need.
Well, I guess another option is just to do nothing because he's already filed it, and it's really kind of moot.
Well, Commissioner, he filed it outside the extension. I mean, his first extension expired on August 16th.
Okay.
He did request before that date for a second extension, but because it had to come before you all, this is the earliest opportunity that I could get to present it to you.
Okay.
I would backdate, if you approve a second extension order, I'd backdate it to when the first extension window closed. So that way he would have a continuous extension.
Okay. That makes sense. Do I hear a motion?
Can I ask a question first?
Commissioner Wallman?
Just for clarification, is this the Matthew Caldwell who ran for Commissioner of Agriculture and served in the Florida House of Legislation?
I do not know the answer to that. He's currently the Lee County Property Appraiser is all that I know.
Yes, sir, I believe it is.
So I just disclose I served with Mr. Caldwell in the legislature, but it will not impact my decision here.
Okay, so noted.
Chairman, I would have the same declaration as Commissioner Walden. Served with, at that time was State Rep Caldwell, and but other than that, I have no bearing on my actions today.
Similarly.
All right, all three are noted. Is there further discussion? All in favor of adopting the extension as backdated? I'm sorry.
I'll make that motion to extend retroactively the date for filing through August 30th, 2021.
Okay. All right. That is before you. All in favor, say aye.
Aye.
All opposed, like sign. All right, that takes us to the next one, Mark Thomas Icy. This is a second order for extension. Gray, you're recognized.
Thank you, Chair. Commissioners, this order, as you said, relates to Judge Icy. He experienced a heart attack in early June, a very serious one, and so the Chief Judge of his circuit asked for initial extension. The Chair granted that, a 45-day extension window. That expired on August 16th. Prior to the expiration of that first extension, the Chief Judge asked for an additional 60 days for Judge Icy. Apparently he's having some health complications due to the heart attack. I do think that there's good cause here given that the health concern. So I would recommend that you approve a second extension order on Judge Icy's Form 6, an additional 60-day window that would run from August 17th, when the previous one ended, until October 15th.
Mr. Chairman.
Yes.
Mr. Chairman, I move to approve extension request 21-04 as presented by council.
Is there a second? Commissioner Cummings seconds. Discussion? All in favor, say aye.
Aye.
All opposed? Show it adopted.
Thank you.
We're scheduled for the exec session at 10. Do we just keep going, or do you want to adjourn and go into exec? Or?
We've still got items on this is all still public session. We still have a number of matters in public session.
Yeah, well, we still got quite a few to talk about legislative. And, so what do you think we ought to do?
If you want to take a break, this is a continuing public session.
All right, and then just hold off on exec.
Oh, yeah.
Oh, okay.
We just continue through.
All right, we're
Could we take a break?
going to take a quick break. We've been in here an hour and a half now. We will reconvene at 10:15. We're actually scheduled to have the executive session at 10. I just conferred with the executive director. We're going to come back here at 10:15 and continue to work through the public agenda, and then we'll go into executive session. There are not a whole lot of items left that will take a lot of time, but I've stopped guessing that a long time ago, particularly when we get down to the legislative recommendations. So we'll be back here at 10:15.
Okay.
You doing all right? I'm good. Sure. We are on item 9, consideration of final orders on financial disclosure. These are fines where there's been no timely appeal and no payment. These are, you have a memorandum in your materials, including the list of fines. Your approval of these orders will result in staff rendering default orders in all of these cases. Filers who currently receive public funds will be referred for salary withholding, and all others will be transmitted to the Department of Financial Services to go to their collection agency, Transworld Systems, for collection. I'm going to recognize Kerry to review them, and then we'll have any questions. If there are any that you want to separate out, we'll consider that. Otherwise, we'll take them en banc.
Thank you, Mr. Chair. Just briefly, in addition to the memorandum, which I know you've already received and reviewed, I wanted to let you know there are a few individuals on the list who have paid or entered into payment agreements, so they will not be sent for default orders should you adopt this list, and that is James Beville on page 1 of the attachment, Colleen Walsh-Conklin on page 6, Stoney Morgado on page 9, and Dale Reed on page 10. So they will come off of this list, and as well as any others in the meantime who enter into payment arrangements or pay. We will not send them to collections. Thank you.
Is there discussion? Do I hear a motion?
Mr. Chairman, I don't know how you would want us to do this, but there's some names on here that I actually know. Do I just say, hey, I have some relationships, but it won't impact me with the names, or how would you want me to proceed, sir?
Well, would that affect your vote in any way?
No, sir.
All right, then you have made a disclosure before the record.
Okay.
Mr. Chair?
Commissioner Waldman.
Thank you, Mr. Chair. Likewise, I noticed a few names on here that I know, but it will not affect my decision.
Okay, so noted in the record. Anyone else? Is there a motion?
Mr. Chairman. Mr. Chairman, I move to enter a final order on the matters of financial disclosure fines where there's been no appeal and no payment as recommended by the Executive Director.
Second.
Motion by Commissioner Gates, seconded by Commissioner Ankers. Is there discussion? All in favor, say aye.
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 All opposed, say no. Okay, show it adopted. We now move to item 10, and this is regarding rulemaking. It appears to me that these are rather perfunctory and non-controversial, but nonetheless, we have to go through the formal process to adopt them in a public hearing. The particular rules that we are amending are 34-8.202, .208, and .209. And these rules re-adopt Form 1, Form 1F, and Form 1X. Unless there's any objection, we will take them up together because they really are a package. But if you wish to separate any of them, we can do that. And I'll recognize Gray to give a brief explanation of the changes that have been made, and then we'll proceed with the public hearing.
Thank you, Chair. As you all know, the Commission has several financial disclosure forms that it issues. The Form 6, 6X, and 6F, the Form 1, 1X, and 1F. Now, as you also know, the Form 6, 6F, and 6X are about to switch to e-filing next year. We're still figuring out the changes that we want to bring before you all regarding the Form 6 rules and instructions as we pivot to electronic filing. More than likely, we'll be doing that at the next meeting, the October meeting. But those changes aren't necessary yet for the Form 1, 1X, or 1F, which will still be issued and then filed using paper copies next year. So what's before you this morning are the proposed changes to the rules and instructions for the Form 1, 1X, and 1F. They'll need to be reflected on these forms when hard copies of them are set to go at the beginning of 2022. The proposed amendments before you are fairly straightforward, as the Chair said, hopefully nothing too controversial. I just want to say each of them have been duly noticed. You can see in your materials we published the Notice of Proposed Rulemaking in August in the Administrative Register. I would add that each of these changes have also been provided to JAPSI. JAPSI has not provided any feedback to us on them. I would take that to mean they're comfortable with these amendments. So if you decide to approve the changes today, the only step remaining is going to be submit them for adoption at the Department of State. I'd ask this morning that you do approve these proposed amendments so we can go forward with printing these forms and get everything ready on the 1, 1X, and 1F by January 1st of next year. There are 6 proposed changes. I've laid them out in the memorandum. I'm happy to walk you through them if the Commission wants to hear a presentation on that. Otherwise, I just submit them for your approval.
All right. Let me first of all determine whether there are any persons who wish to speak. The purpose of this proceeding is to allow the Commission to hear public comment and evidence and argument about the proposed rules. And following the public hearing, which we're in now, we'll decide whether to make any changes in response to public comments or written materials that we have received, and I'm not aware of any that we have received. And we'll decide whether to adopt the rules as noticed, as our Executive Director and as Gray has said, these have been properly published, and we can then withdraw them if we want. We can make changes as we want. We can do technical changes, and all that has to be done in a public hearing, and that's where we are. So, first of all, is there anyone who wishes, other than members of the Commission, who wish to make any presentation in this public hearing? All right. Seeing none, we will then skip down to deliberations by the Commissioners. If there is something that any Commissioner does not understand, we'll defer that to Gray for further explanation, although, Gray, I think you've done an excellent job of outlining about all there is to say. And then we can take a vote on the final action, and once we do, then those rules are adopted. Any questions by members? Do I hear a motion from a Commissioner?
Move to adopt the rules as presented.
Commissioner Carvajal moves adoption. Is there a second? Mr. Cummings seconds. Is there any discussion? None appearing. All in favor say aye.
Aye.
And all opposed say no. Show those 3 rules adopted in bank in one motion.
Thank you.
Thank you, Gray. This moves us to item 11, consideration of administrative actions and matters. And I've asked Kerry to make this report, and also in so doing give a little bit of a discussion about changes that have been made in the staff. I have asked her to prepare a photographic organizational chart, and that will be done and will be distributed to you at the next meeting, so it will assist all of us in understanding who is in what role. There have been some changes, and I think they're all good. And that way we'll better understand how the staff functions. Kerry, you're recognized to give us the report on the commission budget and then on any investigations.
Thank you, Mr. Chair. Commissioners, in every executive director's report, I provide you with an update of the amount of our appropriation we've spent each month, but you've asked for additional budget information as a part of the administrative matters you're considering today. And with that in your materials, I provided you with an overview of the Commission's budget for the past few years, a fact sheet, along with a category breakdown for fiscal year 21-22. Those of you who have served in and around the legislature will likely view the Commission's budget as a continuation budget, as generally there aren't any major changes in the appropriation that we seek from year to year. Significantly, it's important to note that in the years I've been involved with the budget, the Commission has received the budget amount it sought from the legislature with very little variance. You might recall that the electronic filing project is funded not from our budget, but from carry forward funds from the Office of Legislative Information Technology. However, in the current budget year, as well as when we submit our budget for 22-23, excuse me, I have asked for some flexibility to allow our office to be able to purchase any equipment or services or hire additional staff that might be necessitated by the implementation of the project, whether that be on a permanent basis or more likely on a temporary basis. Much of that, if necessary, will come from the carry forward funds. Small agencies like the Commission, I noted at the last meeting, we have little room for error in figuring out our budget. It's always our top priority to be good stewards of the public funds we have been entrusted with. And so by far, salaries and benefits, you'll note, occupy the largest part of our budget. The personnel plan is where funds exist, where we have any vacancies, as well as changes in salary amounts and benefits due to staff changes, as well as minimum wage impacts and any salary compression that might result from that. Those funds can also be used for leave payouts when a staff member exits commission employment. The OPS category in the budget contains our office contract with the Office of the Attorney General, and that pays for the work of our wonderful advocates and their assistant. The DOA expense, the Division of Administrative Hearings expense, is set by DOA and is based upon the cases we've referred to them in the previous fiscal year. And I guess to segue into changes that have happened since September 1, first I want to recognize and congratulate Caroline Clanky. She was promoted to be both Deputy Executive Director and General Counsel. She'll wear both of those designations and crowns, as well as all of that work that comes with it. Caroline, as you all know, has a very impressive legal background, and she's a wonderful person to work with and a fantastic member of the legal team, and I want to congratulate her in her new capacity. In addition to that, it was very important to me with the retirement of Chris and the decades of experience he had with the ethics laws and his encyclopedic knowledge of the ethics laws that we keep the band together. We have a great legal team. They work very hard for you, and they work extremely well together. And in that regard, Gray will be serving as Assistant General Counsel, and Steve has been promoted to Senior Attorney. And I am so thankful for their work and willingness to stay on our staff. And I think they'll be critical to the ongoing work of the Commission, not just with e-filing, but with all of these opinions that come before you and complaints as well. So those are the initial changes. We are advertising currently for another attorney to join our staff, and we'll begin those interviews shortly. and I'm ready to answer any questions you might have.
One of the things that Kerry pointed on, or pointed to, is the electronic filing. We have heard about that for, well, at least the 2 years that I've been on the commission and probably before. And it's a wonderful thing, but it's going to change a lot. And all for the good, but with any change, it doesn't always come easy. It's like trying to turn the ocean liner around, and people are now going to have to recognize that they don't file with their local supervisor of elections, as they have in most cases in the past, and they will file with the Commission on Ethics, and they will file electronically. And most people are electronically, technically inclined today. It's the way we do our banking business and everything else, but still there will be new forms and new ways to do things. Ultimately, it will be easier on the filing public. It will be easier on us, but there are a few bumps in the road to get from here to there. Kerry's been primarily carrying the water on that for many months now, and we're now down to a testing phase, and we will start, I think, in October, actually testing it, and we'll have people on our staff play like they're filers, and they'll file, and we'll follow it through and whatnot. And we as commissioners need to understand how all that works, because we're going to get calls from various places and various people, and we need to understand that process. Even we will end up filing electronically. And as Kerry has said, the Office of Information Technology is covering the infrastructure of putting all that together. But we're going to have to respond to it. Ultimately, it probably means that we're going to have to add some staff people. One of the things that she pointed out to me when we were talking yesterday is that we're going to need a couple of people who speak another language, because it's so prevalent in our state with so many people who file. So as we move forward, I've asked her, and it may not be in the next meeting, it probably will be in our December meeting, to set aside a block of time in our agenda to walk all of us through the filing process. And we can probably bring some big screens in and show exactly what it's going to look like, and so that we go into the new year fully understanding the new procedure. And having said that, I want to thank Kerry and the other members of the staff who've walked along with her, who have brought us to the point where we are today. It's a major step into the 21st century for the Commission on Ethics, and it is being done well, and you would be very proud of the job that our staff has done. So thank you all. Our next item is investigations, and once again, I will recognize Kerry.
Great. Thank you, Mr. Chair. Just briefly with electronic filing, would be remiss if I did not mention Kimberly Holmes, who is the Program Administrator for Financial Disclosure. She's, I don't know how she's doing it, but she's embedded a few days a week downtown with Olitz working on the project, as well as Lynn Blaze is down there embedded as well. There are a lot of staff who've been working on it, but they, I would be willing to bet, have spent thousands of hours working on this project in addition to their normal work. And so they are to be commended on that. And we will reinstitute some e-filing updates in the upcoming meetings. But turning to investigations, at the June meeting, after urging and feedback from commissioners, Chair Lesnoff asked that we provide information to you regarding investigative timelines. And so in your materials, you were provided with a chart reflecting timelines for investigations of complaints filed in 2016 to present. The chart reflects the number of investigations for those years, as well as the average and median time between the order to investigate being entered and the report of investigation being filed in those complaints in a given year. You've expressed concern to staff about the age of some of the matters that come before you, notwithstanding the fact that when complaints are filed, they can reach back 5 years in the statute of limitations. So if a complaint is filed today, you might be seeing allegations from 2016, and then by the time it comes before you, ripe for a probable cause proceeding, those allegations are even older. But notwithstanding that, there is some work we need to do in terms of increasing our efficiency as an agency with investigations. If you look at investigations of a complaint filed, for example, in 2018 and 2019, approximately 70% of investigations were completed within a year, with about 20% taking more than a year. That was a vast improvement over 2017, where it was 34% of investigations taking more than a year. And in 2016, when that number was 46%, taking more than a year. And although pending investigations are in a confidential status, and I can't go into detail, to update the numbers in the chart to real time, I can tell you that now there's only one matter from 2017, one from 2018, and two from 2019. And the number from 2020 that are pending are down from the last meeting, which would have been 25, to 8 at this time. By my rough count the other day in the office, we have about 20 investigations pending from 2021 so far. Currently, your investigative staff has 33 investigations underway. 10 are pending or on deck, and they have completed 83 investigations so far this year. That number nearly matches the average number of completed investigations over the past 10 years, and that average number is 84. Currently, there are 23 complaints in the hopper awaiting a decision as to whether or not the Commission has jurisdiction to investigate. The numbers that I've cited here, as evidenced by the increase in probable cause matters appearing on the agendas, demonstrates your staff's commitment to increasing its efficiency and its efforts already to do so. We've heard you, and the proof is in the pudding. I think you're seeing the fruits of the focus in that regard, and it is our priority to continue to make changes in our processes to increase our efficiency in processing complaints without sacrificing the quality that you've become accustomed to. With a 5-year average of 95 cases ordered to be investigated in a given year and the completion rate of about 84, you can see where the catch-up starts to come into play. We have to find a way not only to match that pace, but to catch up with prior years. I know previous directors have focused on this and done what they could to get that caught up, and yet we find ourselves still here. As you know, we currently have 8 investigative positions. We just filled our 8th position recently. We have 6 investigators and 2 senior investigators. Under a previous director, the 8th investigative position was added with the idea that because the Commission's workload had increased, another investigator would help decrease the number of cases in the queue and increase the number completed each year. In reality, it seemed that we would hire an investigator, and about that time another investigator would leave, and we never seemed to be able to keep 8 in the office. And so now I'm really happy that we have the 8, and I think we're getting some momentum from that. In the last year and a half, we've gone from having 5 to 6 of our investigators having decades of ethics investigation experience, with only 3 with that depth of experience today. So this has been something I anticipated would be something happening down the road. It's happened sooner than I anticipated, but with that change comes fresh eyes and the opportunity to revisit our approach to investigations. At this time, I don't think we need another investigative position, because I'd like to see what is possible with a full investigative staff and other internal measures that we undertake before we consider adding additional staff. We're currently working to develop and implement a pilot program that will be a shift in terms of how we conceptualize our investigations. It'll include standardizations of intermediate deadlines for investigations increase accountability among staff and supervisors, look at training and changes of responsibilities with our investigators and where our support staff might be able to handle some of the administrative work that they have to do along with investigations. As a part of that process, we want to determine what an acceptable caseload is for an investigator, revisit how cases are assigned, look at how supervisors can support and increase accountability, and look at it from a 36,000-foot view of the agency, as well as deep in the weeds for the investigators. To close, I'll just note that so far in 2021, we have 154 complaints filed, which means we will probably run around the average of 230 to 250 complaints filed this year. So that'll be consistent with previous years. And I welcome your feedback and your questions. Thank you.
Are there any questions regarding this? This is very helpful. Commissioner Gates.
I'm sorry, I yield to Commissioner Ankers if she had.
No, I was pointing to you.
Mr. Chairman, thank you. I want to particularly thank Ms. Stillman for taking on this issue. I believe that it is very important to have a thorough and complete and fair investigation and process, and give everyone the opportunity to be heard and to be heard before an unhurried tribunal. That having been said, it is clear from prior discussions that we've had on this commission that there have been cases that have dragged on for years. And as I've proceeded to question those cases with staff, there are a lot of reasons. Some of them are, I would consider, good reasons because they're very complicated cases and stories change, people are hard to find. And some of them are sort of reasons that happen in any organization where, you know, somebody's dog died or, you know, somebody else had to go somewhere. And those are all things that you sort of have to manage within the context of the organization and still get the job done. We've sort of been dragging our tail, to put it in the parlance. And I'm very pleased to see that Ms. Stillman has taken steps to create a more efficient process. It is patently unfair to complainants and those being complained against to have a process that does not come to a conclusion. It also sort of pulls our authority away from us when one of the things that we can do is sanction a public official. And public officials who are publicly sanctioned while they're in office have some explaining to do to their constituents. It's an issue. But if we wait until somebody's out of office and they moved away or gone to do something else, and then we finally bring the case up, and then we sanction them, the sanction has really no effect. So it removes one of our tools in cases when a sanction is warranted. So, you know, I'm interested in the process, how long it takes, how well it works, from the time a complaint is filed until the complaint is finally disposed of. Investigations are obviously the part of that process that takes the greatest time. But I, for one, will I appreciate everything that Ms. Stillman has laid out. I support the actions that she is taking to reduce the time that investigations take, so as long as those times are not necessary. And I'll be keeping close track of how long it takes to get things done. I'm not an experienced investigator, so I can't debate with anybody about how long it ought to take to investigate a complicated case. But I know this, that it's taken us longer than it takes a lot of other bodies that do similar work. And so I'm very pleased to see the changes that you're making. I support them. I'll be keeping track of the metrics and look forward to continued progress. I thank you, Ms. Stillman.
And I might add to that, I had also made this input to our former executive director that unfortunately, the filing of complaints, many of which are meritless, are done for political advantage. And as you all know, a complaint that is filed remains in the confidential bosom of the committee until such time as we find probable cause and take appropriate action. And we had a case last year and involved a very prominent elected official in my county. And I picked up the paper one morning, and lead story on the front page is the ethics complaint that has been filed against this particular person. And the reason is somebody filed it one day and immediately took it to the newspaper the next day. And while we can control the confidentiality of pending complaints until a certain process has gone as far as it needs to go before it's made public, we can't control people who randomly file complaints. We have one complaint that we can't talk about as a commission, but it's in the paper and it involves the governor's race. You know, and the person who filed that, who's also running for governor, you know, they made it public. And it happens all the time. And particularly in local situations, somebody files against a city commissioner or whatever, and the public wants a quick answer. You know, they think that if they read about it in the paper this week, they ought to know what the Commission on Ethics ruled on it next week, and they don't understand the procedure. And we really can't change that, but we can do everything reasonably possible without impairing anyone's rights to be as expeditious as possible. And this is what we have asked the staff to do, and this is what they are doing. It's still going to take a period of time. You know, I know what goes, and so do you, into some of these investigations, and you know, where our investigators have to go and who they have to talk to, and so forth. And it's just not a process that can be done overnight. It's like filing a lawsuit. You don't file a lawsuit this week and go before a jury next week. It just doesn't happen that way. And we have our procedures, and we have to adhere to them. But I'm glad, Kerry, that you're moving in the right direction to keep an eye on that. I think the statistics that you gave us are very, very helpful, and you know, I personally appreciate that. Anyone else want to make any comments? All right, that will take us then to our next.
Mr. Chairman, can I ask one question? And it's on budget. Ms. Stillman, and I apologize, I should know the answer to this, having served on the commission for a few months. Who approves this budget?
Thank you. I submit the budget request to the legislature. I provide it to the Office of Legislative Services, and that is then provided to the House and the Senate. And then if they have any questions about our request, they will definitely reach out to us.
I'm sorry, I asked the question improperly. Let me try to put a finer point on it. Who sitting at this table approves this budget?
As long as I have been involved in the budget, that is something that has been handled at the staff level with the executive director and the deputy executive director as well, and then submitted.
I've served on, as members here have done much more than me, I've served on a number of commissions and boards and public bodies, and this is the first one where I'm an appointed member of a public body, and there's a multi-million-dollar budget, and I don't vote yes or no on it. It's an amazing departure from norm.
You know, that I certainly can understand your sentiments in that regard. I generally do not get a lot of lead time in terms of knowing when they might want that budget submitted downtown. I can find that out, and we can do it at a regularly scheduled meeting, or we'd have to publicly notice a meeting and do a telephone meeting in order to do that.
Mr. Chairman, my only comment would be, if I, as a member of the commission, am in any way held responsible for the expenditure of these public funds, then I believe that we as a commission ought to vote on the budget before it becomes official, either a proposed budget or somewhere in the process. If I'm in the minority, then I respectfully will recede, but I believe that the commission ought to vote on its own budget at some point.
Okay, point well taken. Does anyone want to comment on that?
I'm just trying to recall, and thanks for bringing it up to help us focus on that. Kerry, my recollection is that I have been contacted when there might have been transfers within the budget from one account to another, or from one column or line item to another. And that may have been when I was previously the chair. Can you at least speak to that? Because I know that I have had some input with respect to budget issues, and I'd like to know whether that was unique to that role versus the commission-wide consideration of those issues.
I believe that previous directors have consulted with the chair on matters related to the budget, as I would intend to do as well, particularly given who our current chair, Ms. Lesnoff, with her experience with the budget, but in terms of what the budget might look like, as well as any significant changes to the budget, I do believe that they had consulted the chair.
That doesn't necessarily address Commissioner Gates' point, but I at least wanted to acknowledge that there's been some engagement by the executive director and the chair. But I would still support a consideration if I have enough time to look at it and be educated on it. As educated as we are on investigations, for example, I would seek the same sort of education on understanding the budget, just so I wasn't looking at a lot of things I have no business opining on unless I get some background. But otherwise, I would be willing to take on that responsibility.
Mr. Chair, just one quick question. And I remember we voted on something like this in the past, but it was related to expenditures over a certain dollar amount, right? So I guess that's part of the procedure. But to President Gates' point, yeah, I can't tell you the last time I've been on a board that I didn't have a say or just at least a vote on the budget. So I agree with President Gates on how to do it. I think this is where the brighter minds will help us with that. But I do think we should probably have some say to help with that. Because I think when we think about the previous meeting we had, even with Commissioner Waldman asking, okay, so when last have any of these positions been updated? And it was like 15 years. And that probably is because of the fact that we don't have a say involved with the budget, right? So I agree with Commissioner Gates' point of view.
Sorry, sharing a microphone.
Mr. Chair, if I may. Oh, I'm sorry, Ms. Stillman.
I was just to speak through the chair to your comment about the position descriptions and the updating of those. We fall with, as in terms of personnel, under the legislative policies and personnel descriptions. And so those things are updated through the Office of Legislative Services when the House and Senate leadership direct that be done, is my understanding.
Mr. Chairman, I'm a great believer in budget flexibility, particularly a commission that meets once every 6 weeks. You have to be able to, move when you have to move on issues. So, even if this commission decided that it ought to approve the budget that it operates under, or disapprove it, or amend it, I'd be in favor of whatever flexibility would be practically necessary as between the executive director and the chair, so long as that was understood, that, there were funds that could be moved back and forth between approved line items and so forth. But, we talked about investigations, and, the size of the pipe through which we can push our business is a budgetary pipe. It's determined by how many people it can do, how much work, and how much periods of time. And that is a budgetary issue. So when we, or I can say when I grind my teeth about the length of time that the process has taken in the past for some complaints to work their way through, at the same time, that's unfair if there is a budgetary constraint that we haven't come to grips with as a commission and said, hey, Madam Executive Director, you don't need 8 investigators. To catch up, you might need 10 investigators. You might need 2 other people to do this or that, or maybe you don't. But it is, to some extent, a budgetary issue. And so as we deal with investigations, as we deal with the time it takes to move complaints through the process, we're dealing with dollars as well as other things. So I would recommend for Senator Grant's consideration and for the Commission's consideration that before we send a budget over to the legislature with our names on the letterhead, that we approve it.
So noted, and I think our problem, Senator, and you've touched on it, is that we meet infrequently, if you call 6 weeks infrequently, and as we prepare for the legislative session, 6 weeks is a long period of time. In just a minute, we're going to talk about legislative recommendations, and we'll note that this coming year is an early year for the legislature, largely because of reapportionment. And the session will begin not in March. It will begin in January, which is a little over 90 days away. And committees, I guess first committee meeting is next week or something like that. And they're moving into high gear. In an election year, there's not much going on in Tallahassee because everybody's trying to get reelected. But the fall, when you have an early session in a non-election year, there's going to be a lot of stuff taking place, and budget is going to be largely in place in January when the legislature goes in session. And you served on the budget committee. You know what you do there, and you know how much work is done before the gavel ever comes down on the session, because you've only got 60 days to get the final budget out. And so what you have is a great idea, and I agree with you. I've served on a number of boards and commissions, and we have always approved the budget, but it was not in light of having to have that budget approved by the legislature. I've been on commissions and committees, boards where we approved our own, and therefore we did have to have the ability to look at it. I think our budget is pretty well submitted now for the coming year, or ready to be. Not yet, but will be quickly. Anyway, this may be something for us to ask staff to look at and come back to us and maybe adopt a different kind of a policy in following years. It's probably too late to do a lot for the 2022 legislative session, but as we approach 2023, we may want to take some action. So I think we can direct staff to put this under the microscope and come back to us and talk about how do we handle this going forward. Kerry?
Thank you, Chair. in reading the room, what I'll look to do in October is draft up something similar to put before you in terms of what might be proposed for the next fiscal year, even if I have not yet received direction as to what is expected for us to submit downtown. I can certainly bring that to you, and in the event that we've received information as to what it is we submit, I can bring that to you at that time for public session consideration.
Okay, that will be helpful. Any further discussion in this area of our agenda? If not, we will move to the I'm sorry, Michelle.
I just wanted to mention that at the risk of earning the wrath of all of the commission and staff, but if it helped in the sequencing of the executive director and accomplishing the goal of having us review something that perhaps maybe we should have always been, and it might be a bit embarrassing that we haven't acknowledged that before, we could do what some commissions are doing, which is a Zoom meeting that's just a budget workshop. And it can be efficient and quick and not require quite so much infrastructure to make the meeting happen.
Yeah, good point.
Yeah. Mr. Chairman, I would recommend for your consideration and Chair Lesnoff's consideration, a Zoom meeting solely for the purpose of budget workshop.
Okay. Well, I will refer that to the chairman. As you know, I'm just sitting in today because Chairman Lesnoff is unable to be here. But we will advise her of this discussion, and she and Kerry will work out whatever they want to work out. But Commissioner Akers, I think, you make an excellent suggestion. There are a lot of things that we do in this commission that we can't do by Zoom because of requiring the public to be here and those kind of things. But something like a budget is, a perfect item to do a Zoom meeting for, and I think it could be very effective. Commissioner Cummings.
Thank you, Chair, and not to belabor this point, good discussion, but I think to speak to Commissioner Gates, just from my experience when I was fortunate to be Appropriations Chair a few years ago in the Florida House, I don't think anyone here is saying that this isn't a good budget. It's very purposeful towards some of the feedback we've given from the investigative standpoint. I looked through it and kind of wonder how lean it is, or notice how lean it is with certain expenditures, travel, and other kind of administrative. Obviously, it's mostly on the salary side, but I do think that this board being able to weigh in and support or approve or give feedback is important once it gets to the legislative process, because I've sat in meetings as President Gates has, as obviously Representative Waldman at the time, and Senator Grant, where you've got a speaker and an appropriations chair with a staff, committee head and the approach side that's going over, hey, so-and-so needs more investigators, hey, DOH needs this, hey, ACA needs this. And we poke holes in it, but I think the legislature is always going to be very sympathetic, hopefully, to the needs of this commission and what with its investigative role or other things to support. So I think us weighing in hopefully has a stronger impact on the budget getting approved, particularly if there's any additional funds needed. So thanks for the discussion.
And I think there's another point to that. It not only helps our accountability, because as commissioners we are ultimately accountable for what the commission does, but I think it helps us be better commissioners. I think if it's like I said a while ago, I've asked that we prepare an organizational chart so that we all understand and can look at exactly what the staff does. I think it'd be helpful if we understood a little bit more about how the staff expends, and to have a budget workshop would assist us in that regard. Thank you, Commissioner Gates, for bringing that up. Further comments? Okay, we'll move now to item 12, which is a consideration of legislative recommendations. As I said earlier, we're about 90 days away from the balloon going up for the 2022 session, and it seems like it was just a few meetings ago that we worked on legislative recommendations for the 21 session, which did not go anywhere to speak of. A few things got filed. Some of them were bad and never even were brought up for hearing in committee. I worked personally with the committee chairman in both the House and Senate to try to stop bad things and move good things. And the bottom line was nothing really moved, and nothing disparaging against Senator Gates, but our major roadblock for some time now has been the Florida Senate.
Representative Cummings used to say that regularly.
I think we have a lot of traction in the House. I think we could have gotten a lot done in the House this last year. I talked to the House staff, the House chairman, and they said, you know, we're not going to spin our wheels on this until we get some indication that the Senate might go along. And the Senate has just kind of taken a position that ethics legislation is not a top priority. And of course, we all know that the main priority of this coming session is going to be redistricting, because everybody's going to be very concerned about who votes for who and where they live. And I'm not personally, based on the contacts that I've made in the legislature, and I think Senator Gates, you've made a few contacts as well, I'm not particularly encouraged that, you know, anything is going to move forward. But notwithstanding that, I think we still have to be on record about what we recommend. We made some very good recommendations last year. We had, as I recall, about a 2-hour session where we talked all of them through, and we worked out some very good things. And, you know, I personally would be in favor of almost rubber stamping what we did in recommending legislation for the 2021 session and rubber stamp that for the 2022 legislation. But that's up to the members of the commission as to what you want to do. So I want to give Kerry the opportunity to go over those legislative recommendations and talk about what our options are, and to hear from any members, and then we'll vote on what we want to recommend and send forward. Before I call on Kerry to do that, I want to ask if there are any members or any people in the audience who wish to speak on any legislative recommendations. If so, would you please raise your hand? Yes, sir. All right, would you come forward, and you will have 3 minutes.
David Hodges, Orange Park, Florida. I believe that the Commission's on Ethics investigative processes are being negatively affected by several things. As an experienced investigator with 31 years experience, I speak from an investigative standpoint. When a complaint is filed, it is private, and it's kept from the public domain unless the complainant files it with the media, as has been discussed. But when a respondent files an answer, that answer is no longer seen by the complainant, because the complainant's position as a party has been replaced by the state of Florida. So it's no longer the complainant versus the alleged guilty party. It's the state of Florida versus. So the complainant is out of the process. So when an answer is filed, the commission now votes to accept probable cause or not based upon the staff's recommendations. And when the information that was filed by the alleged guilty party is fraudulent as well and can be easily documented, the commission, having already voted to accept that answer, now has a criminal event in front of it. It can't go back, I'm told by the previous executive director, that you cannot withdraw a ruling that you've made once fraud has been determined in the answer or the response. So as a result, the complainant now must take that information not back to the executive director or to the commission, but must go to the state attorney's office to have criminal charges filed, because the Commission of Ethics doesn't handle criminal charges. You handle administrative. There's a problem there that I think could be handled better if the complainant were still on the party of being able to see that answer and be able to provide a rebuttal. Because in several cases where I have been involved as the complainant, the information that was filed by the respondent was clearly fraudulent, but it sounded good to the commission, and you all accepted it. And I'm not saying this particular body, but I'm saying the commission accepted a fraudulent answer because the investigative staff didn't have the experience or the time or whatever to dig out whether that was a good response or not. So my thought to you would be, you need to figure out a way to have the complainant be able to see what has been replied by the respondent and given a chance to rebut it or provide evidence that shows that it's clearly not right, so that when you do make a ruling, you've got the right matter of facts in front of you. Thank you.
Thank you, sir.
Can I just get clarification on, I think you said you represented an organization and I just didn't hear it.
I'm sorry?
Do you represent a particular organization? I just didn't hear it after you introduced yourself.
I own and operate Fine Tooth Comb Investigations Incorporated.
Okay, thank you.
And I'm hired by various whoever's.
Thank you.
Are there others in the audience who wish to make any public statements? None appearing. I will defer to Kerry to walk us through our past recommendations and what happened or didn't happen and whatever else she wants to say.
Thank you, Chair. I'll be as brief as possible. I know we have a number of matters still pending today. As you know, the Commission is required to make recommendations each year to the legislature under Section 112.322, subparagraph 8. And so that's what we endeavor to do today. It will also be helpful today for you to decide how you want to promote these ideas and proposals with the legislature. Caroline and I are the registered lobbyists for the Ethics Commission, but of course the involvement of commissioners in the Commission's efforts to find bill sponsors and to move legislation is infinitely more effective than just staff. There are different ways you can go about doing that, but we always have to remember we are subject to the Sunshine Law, so having more than one commissioner in a meeting at a time presents problems. We have to publicly notice that. In your materials, as a starting point for your discussion, are your recommendations from last year, which I'll briefly go over for any members who weren't with us last year when they were adopted. You'll want to decide whether you want to continue with these recommendations presented last year, or remove some of them, or all of them, or propose new ideas that you would like to add. So briefly, to summarize, first, the recommendation dealt with the conflicts of interest law, which prohibits an official from having a contractual relationship with a company doing business with the official's own agency. So, for example, Councilman A could not contract with Business B if Business B was doing business with the councilman's city. But if that councilman were to create A Incorporated, and that corporation did business with Business B without violating the law, even if A Inc. is solely owned by that councilman. The Commission has seen this as thwarting the underlying goal of the law, which is to prevent officials from having relationships with companies doing business with their agencies. Last year in House Bill 853, which passed the House floor, had language containing your recommendation here. Similarly, with the voting conflicts law, 853 had language relating to voting conflicts. It, in that bill, addressed the local component to the voting conflicts law, but not the state component. And under current law, local elected officials are able to participate in the discussion of a measure in which they have a conflict without revealing the existence of that conflict until the vote is taken. At that time, they have to disclose it and fill out the form and abstain from the vote. So that means the official can make every effort to persuade their colleagues without telling them or the public about the conflict. By contrast, appointed officials must declare their conflict before participating in the discussion of the measure, and the Commission has proposed that elected officials should have to adhere to the same standard. Similarly, you recommended that state officials should also have to abide by the same standard. Enhanced financial disclosure for elected officials has been in their proposals for a number of years. House Bill 853 contained some language relating to that. In that, you have said that you feel like city commissioners and mayors who are elected should also have to file a Form 6, like constitutional officers and county officers. They currently file a Form 1, and the Commission has said that they believe that enhanced financial disclosure should be applied to those officials regardless of the population of the entity that they represent. Dismissal of complaints alleging a de minimis financial disclosure violation. Currently, you are able to dismiss complaints alleging de minimis violations attributable to inadvertent or unintentional error, except for financial disclosure complaints. And you have indicated your interest in amending the law to allow for dismissal of financial disclosure complaints in that same manner. Similarly, with lobbyist firm audit matters, which are a little bit different, you can dismiss complaints ordinarily when public interest would not be served by proceeding further, but currently that option is not available to you when it comes to lobbyist firm audit matters under Section 112.3215, even when the circumstances justify such a dismissal. You've recommended amending 112.324 sub 12 to allow for such dismissal. House Bill 7043 contained language addressing this recommendation last year, but it died in committee. Also on the table last year was increase in civil penalties. Currently, the maximum is $10,000. That has not been increased since 1994, but due to inflation and seriousness of ethics offenses, you recommended the maximum fine be increased. You also added last year whistleblower protections or whistleblower-like protections for ethics complainants, indicating that the threat of adverse employment or personnel actions in retaliation for a person's filing of an ethics complaint discourages the filing of valid complaints. We don't need more complaints, we need valid complaints. And so the Commission has sought for the enactment of protections akin to those in the Whistleblowers Act for the benefit of ethics complainants. Finally, in your proposals were two notions that you expressed some concern with, and that dealt with representing clients before one's own board. We have opinions from as early as 1977 and even since 2020 interpreting representing clients before your own board, which is 112.313 sub 7. And those have said that when a person serves on a board, they cannot represent clients before that board, and neither can members of their professional firm. This is similar to an interpretation with the rules regulating the Florida bar, which impute the conflict of one lawyer to all lawyers in the firm. The Commission has viewed this as an important public protection and has opposed any relaxation of this standard. With gifts, expenditures, and compensation from lobbyists, the Commission in past years has opposed certain bills which were proposed but did not pass, would have allowed donations from lobbyists or their principals unlimited in amount to certain public employees and appointed officials. if the donations were used towards cost towards injury, illness or disease of the employee, the appointed officer, or his or her child. Such a vast exemption to the gift and expenditure laws aimed at public officials when they are most vulnerable due to undue influence from special interests, you said would seriously undermine the effective restrictions that have protected the public for many years, and the Commission last year voted to continue to oppose an unlimited exemption to the gift and expenditure bans. So that was what was proposed before. Additionally, in your materials, I noted for you an issue with the training requirement that was caused by recent changes in the ethics laws. You know our training requirement is a calendar year requirement, and the law contains language whereby officials assuming a new office or new term of office after March 31st of a given year are not required to take the training in that year. In 2019, the law was amended to add commissioners of community redevelopment agencies to the 4-hour training requirement. However, the CRA board members were not included in the language relating to that exemption that's otherwise applicable to other officials who are subject to taking the training. So you could choose to vote to include in your proposals that the legislature consider amending the law to include CRA board members in that exemption language pertaining to new terms of office. I've reached out to staff directors in the House and Senate ethics committees. I have not had an opportunity to have a conversation with them yet, but I will keep you apprised of any developments in that regard. And Caroline and I will be ready, willing, and able to answer any questions that come along today or as we move forward towards session, and we look forward to working closely with you. And now I'll turn it back to you, Chair. Thank you.
Thank you. That tells you where we were, and where we were is where we is. Nothing really changed. We now have the ability to renew our requests as they were from last year. We have the ability to eliminate some of those requests. We have the ability to amend some of those requests, and we have the ability to add additional requests. So the floor is open for comments or suggestions or motions by the members of the Commission.
Mr. Chairman.
Commissioner Gates.
Mr. Chairman, there is an issue that the legislature will take up having to do with ethics this year. The portion of the constitutional amendment dealing with the 6-year lobby ban will take effect in December of 2022, and the legislature is obliged by the constitutional language to take up the matter of penalties prior to that time. So there will be some ethics legislation moving. The question is, what else? And the language of the Constitution says that on that matter there should be nothing else in that bill. And I know that I have been informally invited, and I'm sure others have been as well, to offer thoughts, opinions, suggestions about how the penalties ought to work for violations of the lobby ban. I don't know whether the Ethics Commission itself wants to take up the matter. One legislative leader told me, if this is something you want to handle, then what are you going to do? Fine them? If somebody shows up and violates the lobby ban, you're going to fine them $500? And then they're going to laugh, write you a check, and go do it again? And that same legislative leader suggested to me that that maybe it's a criminal penalty, maybe it's a criminal matter if somebody violates the lobby ban. So that matter is going to move forward, and I think either informally or formally, we will be asked to offer advice and suggestions on the matter. I'm fine with everything that Kerry has laid out. I think that Senator Grant pointed out to us last year that if we really want to be taken seriously, we have to do, as Kerry suggested, have somebody representing the commission who's on the commission, who sits down and talks with legislators. Staff people, yes, but legislators as well. My strong feeling is that we ought to deputize the chair and vice chair to be our legislative spokespeople, and the two of them working with the executive director. Of course, as Kerry points out, they can't both appear at the same meeting, but you could ask Senator Grant to, if he will, make contact with certain people about certain things, and Joanne to make contact with others about other things, or to appear before certain legislative committees when they're taking up matters. And that's fine with me. I mean, I think that would be an appropriate thing for the chair and the vice chair to do, but I think we do need to be ready to do something when it comes to the 6-year lobby ban. If we do nothing, we may find ourselves with it being treated like the lobbyist audit provision, which is an interesting piece of legislation full of sound and fury, meaning nothing.
Okay, point well taken.
I'll make a motion.
Commissioner Ankers.
I don't believe in rubber stamps, so I'm going to move that the commission support the 2021 legislative recommendations, which is what Senator Grant would call a rubber stamp, but I'll just say it in different words. But also, along with that motion, I would like to take Senator Gates' idea and request that the chair and vice chair serve as our legislative liaisons with input and support from the other members who have appropriate relationships, and exercise those within the context of the Sunshine Law. And third, that they be encouraged to support the most stringent penalties with respect to the 6-year lobby ban, should that be proposed, even should that include criminal penalties.
Second.
Who was second? Commissioner Gates?
Yes, sir.
Okay. Motion by Commissioner Ankers, seconded by Commissioner Gates. Is there comment before we vote? Commissioner Walden.
Thank you, Mr. Chair. And I agree with the motion, and I think it's important that we have certain members designated, but I also want to make sure that staff understands, as well as those designated, the chair and the vice chair, recognize that they should probably call on some of us, the others, to go and make ourselves available if we can to meet with whether it be staff or individual legislators.
Absolutely. I think that's certainly understood.
And may I just add one comment? Sure. That's exactly what I meant by having them support and use the talents of other people on the commission other than me. Also, I think all of us were on the commission when we discussed this last year, although I may be wrong, and we did take several hours to really knit and weave these different proposals and expose them. And I remember it because I was the sole vote against what we did. And so that is part of why I am encouraging. I think that discussion was really healthy and public, and all of those merits remain the same. Mr. Chair.
Through the chair, Commissioner Ankers, does your motion include the additional item relating to the training and community redevelopment agency boards, or do you want to leave that off? That was not on there last year. That was just something that came to us this year.
But that was proposed by, not by us. That came from a third party. Is that right?
No, that was something that staff realized when questions arose this year about the training. So we put it before you just as an idea to include it or not.
It didn't, my motion didn't include it, but I am open to that based on the interests, based on the preferences of other commissioners. I don't have a strong preference.
Okay. Does anyone object to amending the motion accordingly? Seeing no objection, show it amended accordingly. Is there further discussion? All in favor, I'm sorry, Commissioner Carvajal.
Thank you so much. I appreciate it. Normally, I know that this commission has been asked to stand down and let the legislature interpret laws, but I am moved to support this because of not only the individuals with legislative experience on here, but those who have served on the Constitutional Revision Commission and have unique insights. And while I would generally take the posture that it is not our job to legislate or suggest legislation for future commissions to consider that, I think this is very compelling given the composition of this board. So I'm ready to support it, but I think we would normally be in the posture of responding to the legislature in many ways. I do have one technical question just for the executive director. So we're moving the ideas today, but we'll still see legislative language, is that correct? Or is this the last time we'll discuss this? For example, I think last year we debated actually the language that was to be submitted to the legislature. So.
Through the chair, Commissioner Carvajal, you did, I think last year, look at language. There was some discussion and reluctance that the Ethics Commission be so bold as to give language, but sometimes the legislature does ask us for language, and we do have the language that you all agreed upon last year for the various proposals. That still exists should we be asked for it. If there is particular language that you want to revisit or see, we can certainly provide that to you today or in the future.
Commissioner Akers?
And just to refresh your memory, Commissioner Carvajal, I think last year we did exactly this, and then it was a follow-up meeting that we looked at the language on one particular issue. So I guess we could still do that again if we need to reconsider.
Through the chair, I'm not requesting that. I just wanted to know what was likely to happen so that, I mean, those deputized to move forward are fully deputized. So.
Further comments? We have a motion before us. All in favor, say aye.
Aye.
All opposed, no sign. Show it adopted. That then moves us to two things that I don't think we need. First of all, as chair or acting chair, I have no report. And Kerry, you've gone through a number of items that would normally be in your report, but if there are others, it's your turn.
Well, I'm sorry if you're already tired of hearing from me today, but just briefly, I wanted to introduce to you our newest investigator, the eighth man or eighth woman, as it would be, Anna Sanchez. If you would stand up, I know you're here. Anna comes to us from the Department of Lottery. She has some very good investigative experience, and she has hit the ground running with one of our senior investigators, getting trained in investigations, and we're so very happy to have her join us, so please welcome her. And just briefly, we did our annual Phone Fun Day where we phone, the whole staff phones people who had not yet filed their disclosure forms a couple days before that September 1 deadline to say, hey, we're not kidding, those notices we've sent you mean something, you're going to get fined, but we'd rather not fine you, we'd rather you file your form timely. And I think this year, the count was about, we phoned over 400 filers to urge them to get their form in. Transparency is the goal, not the fine. So staff worked very hard at that. So thank you. That's all.
Okay. Is there any further business that anyone wants to bring before the public session? None appearing. I will entertain Commissioner Walden's motion to adjourn, seconded by Commissioner Carvajal. All in favor, say aye. Aye. We are adjourned, and we will look forward to seeing you and those of you in the public at our next meeting, which I think is it December or October? Anyway, whenever we... October 22nd. We will look forward to seeing you at that time. We are running, obviously, an hour and a half late to do our executive session, but it takes a little time to clear the room, set up some of the recording equipment. So it's now 11:35. We're going to convene the executive session. at 11:50, and lunch is provided in the Capitol cafeteria. We're adjourned.
Capitol cafeteria.